Very good. Good to see you. Yes. Yeah. First of all, a very warm welcome to this workshop focusing on legal and organizational interoperability. I hope we will have a fruitful 1.5 hours of a little presentation and mostly discussion. So in that case, I mean, when we turn to the panel and the discussion, I hope you will have your cameras on. That will sort of give the feeling of a sort of we're sitting in the same room. So I hope you will have that. Just on the sort of administrative side, I'm the chair. My name is Anne-Sophie Fink, and I'm working from Dake in Denmark. And then as a presenter and rapporteur, we have Olivier Rousson from CNRIS in France. Here we will, at this second workshop, we will explore the practices enabling legal and organizational interoperability, and we'll do that by having a panel to answer a few questions in order to sort of come around the subject. And you can say our point of departure will be this report from Fair Impact, BP6, core metadata schemas for legal interoperability. That was sort of really sort of take us into to the actually at least trying to perform to put legal interoperability into practice. A little details on the session. The session, as Sarah just mentioned, will be recorded, but only for internal use. And Olivier will take all notes, and you're also invited to add to the collaborative notes as much as possible. And after the session, we will feed this, use the recording and the collaborative notes for our report writing. There's also a shared spreadsheet where we have, based on the survey we had put forward on the questions actually we're talking about today. So I really encourage you also to add your answers if you haven't done so in the spreadsheet. That would really help our work. Yes, I think I've been on that. Please add in the notes. That would sort of really give yourself a stronger position in order when we go into to reporting on the session. So please do that. A little extra. Already, obviously, we have added the survey responses we've got at this time. Not too many. So really, I hope I'll encourage you to go into the spreadsheet and add your answers. We can have with us, take them with us in writing. And also, if you have already put in your answers, also you're very welcome maybe to revise them or add to them before the 29th of October. At least that will, I think, will stay open. So please do that. And again, that will really sort of enhance the writing and reporting in order to get the input from all of you. The program for our session, as of now, a little welcome and introduction. Shouldn't be too long. And then we'll go over to Olivier, and he will present this report as mentioned. And after that, and I hope you will take this as a kind of a takeaway, and of course read it afterwards, but otherwise we'll really take you into it here. We'll have a roundtable with our invited panelists that I'll introduce to you a little later. The questions that you also have in the survey, I only put these three, as the fourth one was the one if you're actually known of our report. But the panelists will be asked this: which are the topics related to legal interoperability that you have addressed in your project or initiative? Which standards do you know or use to implement these legal constraints from a technical point of view? And what additional support would help you to overcome the challenges from the topic of question 1? So we hope we can have a fruitful discussion on these questions, and don't let yourself limit by these. So I encourage the panelists also to maybe step a bit further from the question if they find that fruitful. Lastly, I'll invite the panel and all of you to make suggestions for how we can move forward on enhancing legal and organizational interoperability, of course, with the sort of the FAIR principle as also as our guiding star, and a little bit on the next steps. So that should be sort of the outline, and hopefully we can make this to work. Yeah, and use the chat, comment on anything, and speak up if you see things are moving far away from what you would like to point out. So we welcome you to do that. Yes, just a very few words on legal and interoperability, and I won't read this aloud to you, but again, just to mention that in the EOSC Interoperability Framework, where we take our sort of point of departure, legal organizational interoperability is sort of presented on a very high level, and we hope by in the FAME project and by listening to you, we hope to see how this is actually taking into practice. So we can realize all these very nice sort of intentions and needed and what's needed on the subject of legal and organizational interoperability. And we actually are quite proud to have the author. I will come back to that of this report from 2020. And I'll also encourage you to read it, as it actually lay out very much detail and knowledge how we can work with legal interoperability. And as you see, we have maybe I think I'll just pass that. But indeed, there's also this connecting the legal interoperability to the FAIR principles, as we want to do, is put out in this report. That was actually sort of the forerunner for what later on became the EOSC Interoperability Framework, and was published in 2021. And I'm sure you all know this work quite well, and also the recommendations on legal, organizational, semantical, and technical interoperability in this report. And from working in FAIR Impact on the issues of legal and organizational interoperability, we sometimes have found that maybe the attention often seems to go to the semantic and technical interoperability, and not so much to the legal and organizational side of things, which we indeed think is very important in order actually to use all the benefits from the semantic and technical interoperability. So we need this work, and we need this visibility to the framework of legal and organizational interoperability. And oh, there was a comment. I'll leave it here. Let me not go into this. This is the recommendations on legal and organizational interoperability from the IF I think we someone call it. And again, very much recommendations based on standardization, obviously vocabularies, putting things out in a way that can be addressed by humans and machines on these matters. Of course, licenses are very important, and we'll come back to that. And also how we can harmonize things and actually make these things working for the member states of the EU and indeed broader at some stage. And we'll know with the data spaces, maybe we get a bit more extra help on the sort of alignment on the legal side. Let's see about that. From the first round, we came up with these recommendations, and indeed also for this round, we'll come up with a set of recommendations. So this is, and we'll put them forward in the report, and always possible we can do so. So this was on use of Creative Commons licenses should be aligned. And shield also the data creators from the complexity of working with licenses. And also the recommendation was to have an integrated support program for managing, protecting, and licensing data. So that was the report on the first round. And now, lastly, the objective for today is to discuss legal and organizational interoperability on a practical level, and we hope to have the outcome and as a kind of an assessment of the status of implementations of the fair practices with respect to legal and organizational interoperability, and also we hope to point to areas where actually work is being done, and for instance how to implement core metadata schemas for legal interoperability. I hope this sort of framed your mind for this session and not took too much time. So let me continue by introducing our panel, which we are very proud and glad to have with us today. Renato Neto from presenting EMBL and EBI, BICOVID and EOSC Trust. So he take a handful and bringing all these perspectives in. Great to have you here, Renato. Unfortunately, Marlon Dominguez had to make a last-minute apologies, but we hope we'll catch up with him later on. Then we have Simon Hudson from World Fair and CoData, also giving their perspective on the questions. We have Lise Skoller from Aqua Infra, who's, I can say, from Denmark. That's why I can pronounce her last name. So very welcome to you, Lise. We have Ohad Greta Sori from Ex Officio, and this was, and here comes actually the lead author from the report you saw as an earlier stage. So great to have you here. Lastly, but not least, we have Jessica Parlin from the CSC in Finland, giving us the organizational perspective of things. So also very glad to have you here, Jessica. Like I mentioned, Jessica actually posted things on LinkedIn about legal and organizational interoperability, which not very many people have done until now. So great to have you here. And by this, I'll give the floor to Olivier for a presentation on this report from Fair Impact on core metadata schemas for legal interoperability. So over to you. Should I stop sharing, Olivier?
Oh, yeah, I mean, you can keep on sharing.
I'll just leave it there.
Yeah, that's fine. Good morning, everyone. So,
some people are speaking French.
Yeah, maybe we can turn the Clément's microphone off. Okay. Good morning, everyone. I am Olivier Rochon. I was the task leader of task 6.2 before Salome took over earlier this year, and I coordinated the publication of this report, which is supposed to provide some recommendation on a framework enabling legal and operation and organization interoperability. So as Anne-Sophie mentioned, the starting point was the EOSC Interoperability Framework, but we went even before this report. We really started with the Turning Fair into Reality report, which includes something like 15 recommendations about a fair action plan. We had also the legal interoperability and the fair principle report, and we are very lucky to have Oad on this session because he's one of the authors of this report, and this report includes 31 recommendations which were taken into account into the EOSC Interoperability Framework, which was published in 2021. This one has 27 recommendations, and again, we are lucky because Françoise Genova is with us today and she contributed to the report. So as you can see, loads of recommendations, but very little tips for technical implementation. And this is really what we try to address with our report, provide some really technical recommendation that could be reused by researchers. So basically, we try to build our report on 3 phases. The first one was a kind of landscape analysis of the different metadata schema and control vocabularies available dealing with legal interoperability or organizational interoperability. So we had that landscape analysis on, for example, the Dublin Core, the data site metadata schema, and many others, including DCAT, including the ODRL, etc. And for each of these schema or control vocabulary, we try to analyze if they were fit for purpose for enabling legal interoperability, right? So we had up to, I think, 10 or 12 different schemas or control vocabulary that we studied. Following that landscape analysis, we tried to see if there were some successful implementation or ongoing implementation of these schemas. And we had 3 different use cases in collaboration with other projects, like by COVID, like World Fair. And again, we are very lucky today because we've got Simon Hudson on board, and he's one of the coordinator of the World Fair project. And following these use cases, we try to provide some recommendation and suggest a core metadata schema plus a set of control vocabularies that could be useful. So you can find the link to the deliverable in the notes. I will paste it right now in the chat as well. And in addition to this recommendation of a core metadata schema, we also concluded that another possibility was to use the metadata schema and crosswalk registry, which had been developed as part of the FAIR core for EOSC, and which enables engineers and researchers to map some metadata schemas between themselves. And so even if we recommend, for example, DCAT plus ODRL and DPV, it could be of interest for other researchers to map the DCAT schema with another schema, let's say, for example, the Dublin Core, or etc. So having some such mappings would of course enable interoperability, legal interoperability, organizational interoperability at a higher level, and that would be easier, if I can say. So that's more or less the deliverable that we produced. That was I think 6 months ago. So I encourage everyone to have a look at it, provide feedback if you think it could be improved. And then again, we are quite lucky because we've got quite a lot of people which have been involved in the different frameworks, or even if in this report on the call today, and that will, I think, ease the discussion later on when we'll have our roundtable. So that's me done, and Sophie. So back to you.
Thank you, Olivier, and we'll sort of use this as a frame for our discussion, and then maybe start a bit broader. So I hope to start with this question from the panelists, and I'll encourage you as participants also to add questions or comments in the chat, and indeed in the collaboratory notes also on this. And then my suggestion will be to stop sharing, and I can post a question in the chat too, so maybe we could see each other a bit better. And if you like, you can turn on your cameras. That would be great. So if I can, I'll start. I'll sort of try to send the question around, and I'll stop sharing now, like this, and then hopefully at least we can see each other. So that's nice. Although Jessica, you were the last on our list for the panel, I maybe could start by posing the question to you, which are the topic related to legal interoperability you address in your organization, and feel free to connect to organizational interoperability as well as you see fit. So.
Okay, thank you. So coming from CSC and Finland, I think I need to give a bit of a context, as we are in Finland and we have a very centralized organization and structure. So we are the main state-owned service provider for research services, which sort of sets the scene. And we also have a quite active open science coordination that has been going on for many years, which sort of it makes it partly difficult to separate like the national projects and services and doing from CSC perspective. I would say that regarding like copyright issues and IPR, that's relatively simple in the way that we have for a long time been recommending the Creative Commons licenses, and those are included in our different catalogs. So that's like quite easy in theory. What is difficult actually is more on the like organizational level, I would say, and it's more related to the actual data ownership. That's like not clear who owns actually the data and how our services meet these unclarities and how we can support this, which are the different rights. We are still sort of getting used to the digital world and environment, where we have like copying, sharing, like the crude rights and also access rights, and everything is sort of a mix. So we have been working on in national level on like different contracts on like data ownership contracts and templates for this, so that we could like take this forward, how we actually like interpret these different things, that it's it's a mix of legal and legal and organizational interoperability. Actually, we have to struggle with centralized. We have the centralized metadata services. We have since quite a long time good, I think, or let's say a data structure that could serve the needs. But then, as always with metadata, do we have it, and is it good quality when it's produced all over the place? So not gathering it to one place doesn't necessarily mean it's everything's okay. I don't know if this answered the question, but these were some of my
but that's
reflections on this.
Thank you, Jessica. And feel free to interlink to each other. That would be great if it makes sense to you. And maybe I'll give the floor to Ohad for your comments on the question.
Yes, good morning. Ohad Graber Sudri, I'm the director of Ex Officio, and at Ex Officio we don't have just one project. We are a legal consultancy that work closely with mainly with research infrastructures and with research performing organizations. So within the scope of our work, we do many aspects of legal and governance related to research infrastructures, but one aspect is also we usually address these issues from the perspective of IPR, and including IPR policies for research infrastructures. So the dimension, and obviously it's now been it's actually 4 years ago already. The report that you mentioned that we prepared back in 2020 during the peak of the COVID pandemic, and I remember it very well. The time working on that was an attempt to provide a sort of a bit more comprehensive background to the logic, to the reasoning, and to explain the issues from of legal interoperability from once again from not only from a copyright perspective, but also from other regulatory issues that may be relevant. But in practice, we usually address the IPR policies for research infrastructures, and many, or at least some of the research infrastructures deal mainly with data. So these are often distributed research infrastructures, and the services they provide are the provision of data and research, let's say research objects. And there, the perspective we look at is usually from a copyright perspective. Now, factual data and so on is not subject to copyright, but sometimes research data and research objects involve a sort of a creative element in their development, and in that case copyright applies automatically. And then we're looking to develop policies that facilitate let's say the fair principles, to be able to reuse the data which is provided, and that is trying to promote, I would say, the same understanding within the research infrastructure, which, as I said, usually is a distributed one. So it involves many organizations and service providers. So we try to agree on certain principles within, so the IPR policy addresses those principles, how data providers should provide data, and licenses, of course, recommend. We can't always impose licenses, but we definitely recommend licenses in the IPR policy. Sometimes there's an overlap with the data policy of such organizations. And that's how we look at this. And also within licenses, we try to recommend those that are will be, let's say, interoperable with each other. So if it is a creative common licenses, there are, of course, several of them, and not all of them are actually interoperable with each other. So we try to recommend, of course, the most basic ones if it's a CC BY, or even no right reserved list of metadata, just to get a basic understanding, to set it out in an IPR policy, and to set up some requirements for the data providers, how to collaborate together to avoid, I'd say, regulatory constraints in the sharing and reusing of data or in research objects. I'll stop here. Probably there'll be some more discussion later on related topics.
Yeah, that's a good sort of flying in. So thank you for that. Then I suggest we move to Lise for your sort of answers or comments on the question.
Yes. Thank you very much. I can start also perhaps providing a little context, as we are in this forum. We are representing very different perspectives, of course. The Aqua Infra project is an EOSC project where it is about combining the two domains, the marine and the freshwater domain. So it's two quite different scientific fields, even if it sounds as if it connects directly as it does in reality. But when it comes to the scientific approaches and also the data that are going to be utilized, it differs quite a lot. So, and I can also start saying that we recognize very much also the points that were mentioned by CC. CC is actually also one of our partners in the project. So this about having very different jurisdictions, both inside countries, but also across the borders, and of course within the two domains, very different traditions for working with data, storing data. And one thing is that many data nowadays, of course, apply to the open data standards, but still we also face the fact that a lot of data is also still stored in many local repositories, and even if data are actually available online, you can get the metadata. You can also, and they can also fit the purpose. It's quite difficult also to get, because the approach for our project is to provide seamless access across those domains. So one thing is discovering the data sets that could fit or is available, but another step is actually to get access through those different layers of licensing. So that's one of the very specific challenges that we face in this project. Yes, I think I'll also stop here.
Yeah, that's fair enough. And also, I think now we have all these different perspectives into the question, so that's very good. Then Simon, please give us your comments to the questions.
Yeah, thanks. So hi everyone, Simon Hudson, Executive Director of CoData, and so I'll talk from the perspective of the World Fair project, as has been mentioned. The World Fair project itself has ended, the EC funded part, the Commission funded part, but we're continuing a number of the case studies and some new case studies, and we're continuing the work on the cross-domain interoperability framework. So I'm going to speak from that perspective. Mm-hmm. In a sense, I'm going to either dodge or reject the question and the premise. Which of the topics related to interoperability have we addressed? Well, all of those topics, A to E, are relevant to what we do and are addressed in what we're concerned with, though I suppose we are most concerned with data protection and privacy. But I'll flip the question a little bit and say, really the approach that we're concerned with is how to automate and maximize access to sensitive and potentially disclosive data in various ways. And in the case studies that we've been working with, there are 3 ways of addressing that challenge. So the challenge is we have a research project, we have research questions, we have a data provider and a data integration service that is working with the research team. And the mission of that data integration and providing service is to try and enable the research to be done in a non-disclosive way and in a way that respects each of those categories of data protection and rights, etc. So what I'm going to go on to now is probably not a comprehensive list of the use cases, but we'll highlight three, I think, of the most important use cases. And by that, I mean the ways in which we maximize that access. So one, federated analysis or data visiting. So that was used in World Fair Work Package 7, is continuing to be used and worked on by that partner. It's the African Population and Health Research Center. They have a new project which we're part of called Data Science Without Borders. There, the idea is federated analysis across 4 African health research centers. It's done by preparing the algorithm against synthetic data and then sending the algorithm to a containerized data collection. And what you get back is the output of that analysis. That's one method. Data visiting, it's sometimes called, etc. So the researcher never has contact with the actual data. They prepare their analysis against a model of the data and they get the feedback. Now, that allows us to avoid, in a sense, all of these issues, but we shouldn't neglect it because it's really important. But what that requires is very detailed data description, and that's a theme I'll come back to. The other one is fine-grained granular access to less disclosive variables. And what that means in essence is that you might have a data set of which only a few of the variables, a few of the columns, if it's tabular, are disclosive and problematic. There we have data engineering, which allows access to a modified version of the data set. But you have to be careful about triangulation, etc. But again, what we need is the detailed data description. And then the final one is automating access permissions and accreditation. So a lot of manual labor goes into assessing the accreditation of the researcher's access to particular data. This is very time consuming. The way in which we can maximize that and automate it to the greatest degree possible, the better. Now, in particular, the second and the third use case that I described can often go together, depending on the level of disclosure in that assessment. So why have I gone into that detail? Well, hopefully that gives us an idea of the sort of solutions that we're working on and that we're interested in World Fair Plus and in and the projects that and case studies that are flowing from that, and in particular in CDIV. So this is getting a little bit into the next question, but what we need in particular are clear, machine actionable articulations of the rights, the sensitivities, the disclosure risks. And we need that in combination with very detailed description of the data at the variable level. Now, we're not saying that this is something that researchers should do, far from it. We're not saying that this is something that should be, that investment should necessarily be made for all data sets, but where the data set and the research questions are particularly valuable and where we want as a data infrastructure to provide access to researchers for those uses, then it's worth putting that effort in for the detailed data description and the articulation of the rights and access. And hopefully that jumps us onto the next question in due course to describe those standards.
Yes, thank you, Simon. Actually, now we've jumped into solutions, which is also very relevant, and we'll come more into that. Yeah, I'll promise. But let's first hear from you, Renato.
Yes, okay. Thank you very much. So I have to, for a beginner, I just have to mention that I apologize if my knowledge on the projects it's a bit limited, because I was asked to talk about EBI, and EOSC Interest, and my participation in all three of them is a bit limited. So If anyone in the project is in the call, feel free to complete my answers. But what I can say about the BI is that it's highly dependent on the resource or the project, because the BI is a large company that encompasses several different resources, several different projects, and each one is likely going to have different answers for this question: which license they use, which data protection, etc. For example, I can tell you that UniProt, which is a large repository of proteins, has its own license, which in this case is the Creative Commons. And most, as far as I know, most EBI resource use Creative Commons. So it's highly dependent on that. Same for ByCovid. ByCovid incorporates several institutions. And the idea, at least on my side, was to improve discoverability. And that was a big situation on how to each participating organization or provider answers these questions was also a big, large situation. So this is the case for all of these. And EOSC Entrust, in this case, is trying to solve these with its own providers at the moment. So this is what I can tell you about this question specifically. Yeah. That's what I had. Yeah.
Yeah. Yes. Thank you, Renato. Yeah, that's you have a handful on your plate, so that's fully understandable. I think we now got sort of yeah, very sort of different roads into answering this question. So I think we'll really sort of draw a landscape. Then with the and I'm thinking, I mean, maybe in the next question, please also feel free to comment on the first the answers from other panelists, and we'll get back to all of you, I think, in the end, and sort of try to invite you in. So I suggest we turn to the next question. I'll just share it on the screen, and I'll put it in the chat. So with standard, and many of you, some of them mentioned in Olivier's presentation, and already also in your answers to the first question. Do you know or use to implement these legal constraints from a technical point of view? And I think maybe if it could sound okay, I'll suggest we'll take the question in your opposite direction. So starting with you, Renato, and feel free also to comment on others' answers. I'll stop sharing, and hopefully we can have the panel to answer this, and feel free to also maybe ask the audience things if you'd like. So Renato, do you have a
yes
your point of view to this question? Let's put it that way.
Okay. I can tell you that we are mostly using DCAT, as far as I understand, from these topics that you mentioned, from these standards. In ByCovid, we had several providers that were sharing data with us, and to facilitate that, we have proposed DCAT as the one format for people to expose them, for the different resources to expose them. Although, since it's a more complicated format, we have also exposed a custom XML schema for this, and we had split responses for this. We had providers that had chosen the custom XML because it was easier to work with XML compared to RDF. And then we had users that had preferred the DCAT. So we had worked with both DCAT and this XML format for ByCovid. Although initially in the project we had a look at ODRL if we could support it, but at the moment neither any of our providers had had used it. And personally, I don't know if anyone in the audience disagrees with me, but from my mathematical background, it reminded me a lot of first order mathematics when I looked at the definition of ODRL, which is the kind of thing that you look, you don't understand anything, and then you study a bit, and then when you look, you can understand it. So it feels like ODRL felt like the language that you had to put a lot of effort into understanding it. But if something is defined in it and you can understand it, then it's easily usable, let's say.
Mm-hmm.
So in the end, we never decided to go into it, but we had a look at it. In terms of EBI, we mostly use this custom XML format to expose data, since EBI handles mostly public data. We do have the resource of the EGA repository, which is the European Genome Phenome Archive, which deals with identifiable data, which is not public, but I'm not aware of the metadata formats that they use, unfortunately.
Fair enough. No. There's a question from Cal in the chat. If you meant XML and not JSON?
We supported both. We
Okay.
had, I think most people use the XML version, but there was also a JSON version.
Thank you. Thank you. Yes, Simon, any comments on this when we sort of go into the really implementation level?
Yeah, of course. So I mean, I sort of tried to set that up in the transition. So what we want is the machine actionable articulations of what cannot be done to the data, combined with data description at the variable level. So what we recommend in the cross-domain interoperability framework in CDIF is for the discovery module and for a lot of the data descriptions, schema.org expressed in JSON-LD, though there are crosswalks to DCAT. But the projects that we were working with were using schema.org as JSON-LD. And that includes a number of the warfare case studies. Then in terms for the machine expressibility of rights, ODRL, of course, our current assessment in CDIF and the CDIF work is that there will be a need for a number of additional vocabularies to be added to ODRL, and that's something that we're discussing and scoping at the moment. And then in terms of realizing the data description that's necessary to implement that in an automated way, whether that's the federated data visiting or whether that's the fine-grained access, both of those use cases require detailed data description, and there we're talking about data description at the variable level using DDI-CDI.
Yes, thank you. So sort of very many different standards. I can see Jessica reminded me that she had to leave.
And if I can just jump on that, I mean, many different standards. Yes, yes, of course. And one of the approaches that we took in CDIF is precisely that recognition. You know, we're not the information and data world is so complicated that we need multiple standards to address particular parts of it, particular functions, particular use cases. You know, that's kind of obvious, but sometimes we need to recognize that. And the approach we took in CDIF was to look at each of those multiple functional requirements and try and identify where a standard is already being used and then recommend that. So it is indeed a network or a framework of multiple standards which needs to be used in conjunction. It's kind of obvious, but it's worth banging home. You know?
Yes, yeah, understand it. It gives a good approach. Renato have a comment, but yeah.
I just wanted to comment that there is also several initiatives to work with these different schemas. So in the case of our partner project, the EOS Faircore for EOS, they also have the mapping registry now, which is in development as far as I understand, but the idea is to have a registry of different mappings between different schemas and things of the nature. That's all I wanted to comment.
Yes, very good to add this at this point. I'd like to jump to you, Jessica, because you reminded me that you had to leave. So please, a comment, and then you're free to go.
Yeah, just very shortly that we made an effort in many years ago to write the national guideline for expressing the rights, and we also, as we usually do in Finland, we included the GLAM sector. So we and the idea there was that we really wanted to make it like machine actionable to also have references to specific legislation, for instance, so we could, like, if the legislation is changing or something, you could like automatically, for instance, in the National Archives, like, or in the library, if say the copyright laws changes, you could change or automate this kind of when the access or rights status is changing. And we implemented a version of it in our national research metadata hub, Metax, and I added a link to the notes where you can find the, the API. It's in DCAT. We probably should do a revision and look at it again. Now, not much has happened. But yeah, so that has been our thinking, and I don't know, I can't tell about the more technical details, but you can find information in the Metax documentation.
Yes, thank you. And I think it's valuable that here we are mostly presenting project, but also we also have a national context that we can maybe influence in some ways. So thank you for that. I think I understood. I didn't would like to jump this question, right? That's not. Yeah.
Yes, that's right.
Correct. Yeah, that's fine, because now we're really into the project kind of implementation kind of view. So, Lisa, comments on this question?
Yeah, and perhaps I should also jump the question, because I can say that one thing is that we are facing the challenges, but we have not come to the point where we know how to solve how to deal with those legal aspects of it. The first step is actually to try to get the things working, and then we point out the challenges that we are facing in this connection.
So that's
yeah,
that's perfectly understandable. I think I'm looking at all the names in our room, so please feel free. If anyone would like to comment on the answers you got here, or panelists who would like to what, please feel free to join. No? Yes. Then I think. There's a comment from Xavier, and then from Hilde. So please take the scene.
Okay, thank you very much. Well, first of all, I would like to say a big thank you to Ohad due to his or their report ex officio, which was very valuable and very interesting for the ones who were analyzing those legal matters. And it was fantastic that it was in the year 2020, because it gave us a huge amount of clues related to what was going on in the legal landscape related to fair data. So that's first of all. Second,
thank you very much.
Thank you to you, Ohad. And the second thing that I really find that is a huge challenge in legal interoperability is that legal activity is always an hermeneutical activity. That is to say, we are the whole day around making interpretation about what does something mean. And we lawyers, we don't even agree on what is the correct interpretation of something unless then we arrive to the European Court of Justice that will give us what is the correct interpretation that we have to give to a certain term. Therefore, the vocabularies that we could produce, or the ontologies that we could produce, are always, we could say, I'm not going to say ephemer, but they are always on a position that they must be continuously reviewed. And this happens, for example, to certain activities which are crucial, for example, for digital identifiers, permanent digital identifiers. According to United States jurisdiction or Canada jurisdiction, they would just be a fact. That is to say, it is a reference that is made to another object and this other object could be subject to or data rotten or data drifting. But according to European Court of Justice, URL, that is to say then a permanent identifier, is a fact of public communication, and therefore it can infringe copyright. This is, I don't agree with European Court of Justice, but who is Javier de la Cueva who not to agree with Court of Justice, European Court of Justice? Okay, this is what they say, and this is what we have to take into account. Therefore, we do have two big, huge challenges. First is the hermeneutical, the interpretation challenge, and second, it is the drifting of the concepts that we have there, that sometimes we have to wait 15 years until here comes a court to say something that it can be even irrational, but we have to suffer that interpretation.
Yes, good point. I mean, we are dragging that along, the interpretation from the jurisdictions. Good to hear. Yeah, Hilde, and then Simon, and then we need to jump to the next question. But very good to have you.
Thank you very much, Anne-Sophie and Olivier, for convening this cross-expertise panel. Again, we see how important it is that people with different expertises work together to find common solutions. Here you have lawyers, you have technical people, you have metadata experts, and all of that needs to continue to collaborate in order to achieve something. Then I just wanted to comment on some differences between what Renato points to with the FAIRCORP or EOSC kind of mapping repository and Simon's CDIF approach. You can say that CDIF are more mapping to one rather than mapping each one to everyone to everyone. And it's not the same to use something together as it can for CDIF than really to map something. To use together can be to link or to whatever. You don't need necessarily to map one component to another component. So that is a little different thing. You can have CDIF and you can have other standards. You can map to those. But within CDIF, you can use these things together. So just as a clarification. And that is very powerful.
Yes, thank you, Hilde. Maybe Simon wants to pick that up, and then we'll proceed. Thanks.
No, I mean, in terms of that point, I would just thank Hilde for that clarification, which I don't think I stressed when I talked about using the different standards together, and that is important. The point I wanted to make was to sort of come back a little bit to something you said at the beginning as a premise, and to push back on it a little bit. It is not my view. I don't think that we neglect legal interoperability. I think there's a lot of work on legal interoperability. I think there always has been. So I don't think it's the sort of the poor cousin in relation to technical or semantic interoperability. But more importantly, I think that, and Hilda's hinted at this as well, and actually I'm in Bergen and we were discussing this yesterday. The interreaction and interrelation between the semantics and the technical and the legal interoperable. I mean, I think this is, I hope this is speaking to the converted, and I think this is baked into the approach that fair impact has been said. But again, I think it's sometimes worth pointing this out. And notwithstanding what Javier just said, yes, it can be difficult to articulate in a clear, human readable, let alone machine readable way, what the rights are. Nevertheless, that is our challenge. And we have to start with the low-hanging fruit, because there are some things that can be articulated in a clearer way. And you know, we can go on to the other issues in due course. But this is the point at which the people that understand the legal privacy rights requirements, need to work very closely with the technical people to articulate those in a machine actionable way, and then to be implemented. And I think it's really important that we don't regard this as two separate worlds. They're two separate points of activity. And it is really important that we have those clear articulations and then they're encoded so they can be acted upon. And that's a workflow, a division of labor, but there has to be that interaction. And again, I think that is kind of an obvious point, but it's worth clearly articulating, because I think in some of the discussions it becomes very confused and people want to separate these areas of activity, have people working in different groups and all the rest of it. And I think it's unconstructive.
Yeah, thank you, Simon. I think it indeed for our discussion it's a good point to stress. And I think for some of us still learning, I think it's very, very great to have these sort of maybe for other people's obvious connections made. So thank you for that. I suggest also we turn to the last question for the panel. So let me just share again. And maybe I think we can use this always for a sort of a conversation starter to drag in from all of you who are here. I mean, a room full of big brains in front of me. So, what additional support would help to overcome the challenges for the topic represented here? And maybe we could start. Let's no, we don't have Jessica. Oh, let me know if you would have a comment on this question from maybe a bit of a broader sort of a.
I have a comment which is a little bit, it is indeed broader, and maybe we can save it a bit later because I don't want to divert the focus of the discussion. Okay. It's just a question that I have to myself.
Yes, very good. We'll keep that maybe to for the last bit. Maybe you can start there. Thanks, Lisa. Maybe you would have. Something to say, at least that, for instance, you didn't have an answer to question 2. So maybe what could help you?
Yes, but actually, I think that what we are doing now, actually getting more knowledge about, as you just said, many of us, those specific aspects are not the ones that we are normally focusing on. One thing is, of course, making data available that we are doing all the time, and making other digital solutions available for others in the whole open and fair context. But I think this is about actually addressing those specific issues on this legal and organizational operability. I think what we are doing now is what, as a starting point, helps us. I can't say directly what we will need. We will have to be more specific on the challenge, the technical challenges also that we face in making our solutions work.
Thank you, and absolutely fair enough. I really hope this could support the work. Then, yeah, Simon, maybe you for your comment on what additional support would overcome challenges.
Yeah, I mean, I think that's my basic answer to that is that it's less about specific support than about methodology. And I think I get a bit impatient that some of our discussions are rest at the level of generalities. And I think if we're going to make progress, we need to be more specific and more precise in what we're talking about when. And what I mean by that is precisely what use cases we're trying to address. And yes, sometimes this can be complicated. Yes, it can be challenging to articulate, but I think all the effort we can make to be as specific and precise about the use cases we're addressing. And then, of course, step back to make sure that we're not solving one little niche problem that, in a way that can't be applied elsewhere. So you've got to keep doing that iteration. But what are we trying to address? What additional aspect? I mean, and this is why I flipped the question at the beginning, because yes, we can talk about N types of interoperability, but in reality, what we're talking about is how do we maximize access and usability of data for legitimate purposes. And I think we've got to bear those use cases very clearly in mind and try and find functional ways of addressing them.
Yeah, I like the use case sort of frame for these things. Yes, thank you. Renato, sort of overviewing all the 3 projects. Bill?
It's a difficult question for me. I'm sorry, I'm trying to wrap my head around it.
Yeah, okay, better.
No, but I think because if I'm looking through the interoperability side of things, it's a lot of the challenge that we had was for people to choose a specific way to expose their data, if they can expose their data, and how to expose that data best, like in a technical side of things. So I think guidelines are definitely what we're missing, at least from my experience with by COVID. It was a lot of like choosing and mapping things, and discussing with people how they are going to expose that data and what are the limits on that. So I think guidelines are definitely something that would help, but as mentioned before, these guidelines are not something easy to do because there are different use cases and so on. I think I'll stop here because I'm not super sure. I'm still thinking about this question while I'm speaking, so it's probably best I don't.
Very good. Maybe, I mean, if anything comes back to you, and that allows me to really encourage you to put all kinds of your thoughts, also kind of thoughts and considerations into the notes, or write to us. I think we really need all these sort of will help us sort of to really report on your viewpoints. So please do that.
I just can't find the hand. Could I just add a comment?
Yeah, sure. Sorry.
It's just it's about, of course, we fully agree in this about specific use cases, and my comment was also very much relating to this specific challenge about the licensing and permission parts, and how to actually solve that in a technical way. So we are back to that. It is also about actually trying to find the solution in the technical sense to this kind of challenges.
Absolutely. Yeah, sure. But yeah, and coming back to sort of defining specifically what you need to maybe narrow down what you need to address, but let me know. Then I suggest we go to today's last question. Really inviting, hopefully trying to invite all of you to give your comments, and maybe as this kind of session, we don't need to sort of make sort of very strict conclusions, rather than to really give time to have all the inputs and viewpoints. So so if I can invite you to give your suggestions for how to move forward on the enhancement of legal, and maybe we haven't given that much attention to organizational interoperability, as I think we tend to think that the complexity, or maybe less complexity, as Simon would say, is on the legal side of things, but maybe taking the both into action here. So if I could invite all of you, and let's start with OHA, and we can also definitely invite the panel, but also all of you to comment. Please do. Stop.
Yeah.
Sharing.
I could suggest by starting with the training and education. I feel that this is an area where there's a gap it's a large audience, and you can't expect researchers to understand IP, IPR, or copyright, or GDPR, or the relevant topics. So I think some sort of training for those who are, at least once again, looking at this from the perspective of research infrastructure, training for those involved in the research infrastructure, if it's service providers, also those that are in the central hub, simply to bring everyone on the same level of understanding, even if it's a basic understanding, and then to make other forms of training, education, and material available also for users, definitely for data providers. So that's where I feel that there's a gap, even between those that deal with the topic. There's, those that have dealt with the topic and deal with the topic, there's still a gap in the level of knowledge and understanding. So somehow it should be mitigated, probably training, education.
Yes. Yeah, thank you for that point. In my notes, I also added that how this could actually relate also to the implementation of the FAIR principles. I think training is could be for some, because what I also we see here is that that's some people really sort of are heading into things and creating solutions, whereas in other things it's really hard to grasp. So I think we'll see those two. So please, any other comments on how we could move forward on these important topics? I see a hand from Maggie, and then Hilde, please.
Yeah, hi. I'm Maggie Hellström from ICOS ERIC. So we're one of those research infrastructures that were mentioned throughout today. I think one thing that we are really struggling with is having a point of contact where we can check whether our suggested formulations of policies and license requirements and all of those legal interoperability related documents and setups that we have defined for our organization, that they are indeed correct, and that we are not sort of having things in our mind which we cannot ask for, or we have forgotten about aspects that we should definitely also have included. So I remember having discussions during the EOSC Future project with some experts. There were some workshops organized, and really attending that and realizing that, oh man, we are not 100% aligned with this. But then it sort of stopped because we didn't know how to continue there. So I think if there could be an EOSC related platform, not only for training, but really for providing good examples or really strong suggestions, as we say in Swedish, point with the whole hand and not just with the finger, sort of really well defining that this is what you should do. You cannot just say that we are collecting IP addresses to do blah, blah, blah. We need to be very concrete and to be aligned with GDPR, for example. So I would really look forward to something like that as well, a good reference resource, and maybe even the possibilities to very easily get in touch with an expert. Of course, maybe paying for that service, but knowing where to go.
Yes. Yeah, good sort of, thanks for this, Maggie. Yeah, and Hilde?
Yes, I'm thinking, I don't know what will happen after World Fair, but I know there will be new projects that have been approved now that will also touch on these topics. And we at SICT, for example, will be involved in one called Fidelis, by trusted repository, and that has a kind of legal component. And also in Climate Adapt for EOSC, where co-data are more involved with ourselves, but we will also be involved there. And a question, and there are probably others, there are many, and how a kind of collaboration could continue across these projects to kind of make a little convergence and not everybody just doing their own stuff. That would be really nice, I think, but I don't have a solution.
No. Thanks for that. Yeah, anyone else? How could we support the how we move forward? Now you heard different sort of yeah, ways by the panelists. I don't know, maybe you, Simon, I'd like to invite you to suggest, because you said you was a bit impatient. So what can we do?
I mean, I know what the approach that we're taking, which we feel is the most constructive. On a wider level, I mean, I'll describe that approach in a moment, but on a wider level, I suppose, it is coordination and understanding what's going on in various projects. From the World Fair Plus, so World Fair Plus is how we're describing the new case studies that we have, and we're going to manage those in a very similar way to the World Fair project, and use them to implement, get feedback on, further refine, and extend the current CDIF profiles. But in terms of, moving forward, there are obviously there are a multitude, many aspects to legal interoperability and addressing the sort of challenges that we want to address. But we certainly feel very strongly that the low-hanging fruit and the area to address is in the capacities of the research infrastructures, and to prioritize that. I could add to that the particular institutions that have strong research groups in particular projects, but above all the research infrastructures, we have to start somewhere. And I think it's the place to start, in my view, is those infrastructures that furnish researchers with combined data sets for the research they need to do. And those data sets where there will be issues of legal interoperability and disclosiveness. I sometimes fear that when we talk about training researchers and awareness, there's a risk of trying to boil the ocean and not address the priority topics. And I think the priority topic, in my view, people will disagree, is building the capacity of those research infrastructures, because that's how we can leverage the expertise we need to develop those machine actionable descriptions of what can and can't be done, what may and may not be done, and to present those in an encoded way that maximizes access, and then use that as models for other institutions in a sort of, a model filter down sort of way. But with limited resources, with a strategic wish to avoid boiling the ocean, I think we have to start there. And certainly that's the approach that we're trying to take in World Fair Plus and in CDIF. Our recommendations are directed at primarily at research infrastructures who can implement these standards and provide a service for the researchers that they engage with.
Yes, thank you. I think it's we have these and maybe we don't need to say either or, but maybe we can play with both perspectives. We will do that indeed in the reporting. Renato?
Yes, so I think I would go in between, I guess both Simon and Maggie, that I think having the standards is definitely a big priority, something, a recommendation that people should use and can read and everything. But at the same time, I'm thinking of the people that have to implement that. And besides studying it and understanding it and every training involved, there should be a way for them to verify that. And I think that's what was mentioned, that there should be a people that you can talk to and everything. But I think there should be more of a tool. I think the tool situation should be where people go and verify and make it. I don't know if there should be an assessment or some kind of guidelines to check this, as it was a checklist before, I remember, and there is the assessment tool for that. But I think the idea that people can go on their own and verify that they have done the correct job, everything it is, and then this can be contacted on a different level for a person to go there and verify it, I guess. That's all I wanted to mention.
Yes, I think we are very getting into things that could be done at least. So thanks. Ola, please.
Maybe just a short comment in relation to the previous two comments that were made here, is that in practice, research infrastructures, especially those that focused on data, they're very limited in their powers. They are mostly distributed research infrastructures, which means that they may have a central hub, which is limited in their capacity, and they are very much dependent on their nodes, service providers who are separate legal entities, and they are mostly data owners and data providers. So I think it's a struggle for research infrastructure to agree on principles and policies, and that's what we see in practice. So just to make this comment, it's a limit. Because there are weaknesses inherent in the nature of our distributed research infrastructure.
Yes, thank you, Oha, for also having these insights. So Simon, and then Maggie, and then please.
Yeah, I just wanted to respond to that. So that's a very specific understanding of the term research infrastructure in the European context. And so just to clarify, when I'm talking about research infrastructures, I'm not primarily talking about distributed federated infrastructures of that sort, though they do clearly in the European context have a role. I'm talking about research infrastructures in the sense of those agencies and institutions. It could be data archives in the social sciences. It could be research institutes that have a community that they serve, that provide a community of researchers with data that they need. There are various types of that. I think research infrastructure is a perfectly good term for it, but if we want to talk about data centers, data services, data repositories, whatever. But the important thing is that active engagement with research community. It's not just somewhere where you deposit data, it's a service that provides data products. Yeah, and there are many, many examples of those in different research areas, sometimes federated, sometimes not. And it's those institutes that are the target of our recommendations.
Yes, thank you. With a bit of a broader understanding. Very good to have. Maggie, and then maybe we should wrap up a bit.
Yeah, very briefly. I just wanted to say that this uncertainty that it reigns both through those infrastructures as an higher level centers or that Simon just mentioned, and of course all filtering all the way down to the people actually doing research on the ground, so to speak. This uncertainty about the legal aspects, about which license to apply, fundamental questions like who owns the data and is allowed to put the license on my data, which often isn't the data of a researcher, but of the institute or whatever. I mean, all of this provides a really easy way to cop out of participating in open science, in fair science, etc. You just say, no, it's so unclear, so I'm just going to hold on to my data as much as I can and not share it with anyone except my trusted colleague across the hallway. So I think it's really urgent that we sort out these things, because I see this as a big stumbling block towards actually being able to take all this fantastic data that we have and address, for instance, sustainable development goals and all these really major questions for the whole of Earth.
Thank you, Maggie. I think it was a very well put comment to round up our discussion here. That really we have sort of challenges on the highest level, and still we have solutions, practical solutions, maybe use case centered, but maybe to show that if this is sorted, we can do something. So I think we really got sort of drawn a very, and you always say that complex, but it is a complex picture of the landscape for legal and organizational interoperability, and we will really put an effort into drawing this into our report. So let me just finish by one more a bit boring slide. But even though we will use the note, so I mean, do fill us in and use the link and add to the notes. And of course, we also have the recordings, which will help a lot. And also, I'll of course encourage you to answer the little survey in the spreadsheet. Again, that would really sort of give us the data. So that would really help the work here. So please do that. And and now I'm not even in the mode. Sorry. So we will have the report, and now I can't remember when there's a wrap up session for all the series. You'll get informed on that, and so maybe we can give you a bit of a summary there, but of course mostly in the report. And then also in the project Fair Impact, we're planning to produce a white paper on all these synchronization force workshop, where we really get all these perspective from project initiatives, organizations, maybe even countries together. So we hope to put that forward in writing, of course, and hopefully as Simon would put it more into action. We really like that. So by that, and sign up for the Fair Impact newsletter. It will make it easier for you to follow the work. So thank you very much for all your input. I can say for myself, I really got much better, much more and better insights into the topics we are addressing here. So thank you for that, and I wish you all a nice day. And please do the notes when you have time. So thank you, and of course mostly to the panel and to all of you for being here and interact. So thank you.